Minister of Justice Abubakar Malami had approached the court with an ex parte motion urging the court to do so. President Muhammadu Buhari had earlier given written approval for the proscription of IPOB pending legal process. The motion ex parte was supported by 7-paragraph affidavit which overwhelmingly bears out several acts of terrorism of IPOB that are prejudicial to the interest of the federal government of Nigeria and her citizens. And upon consideration of the federal government's application as presented, all the orders were granted as prayed by the federal government. And on the program with me today are 3 legal practitioners, as usual, on democracy and the rule of law, who will be taking a look at this issue. You're welcome. Barrister Steve Adaramo, it's good to have you on the show today.
Thank you. Thank our also.
All right. I also have with me Barrister Samuel Ame. You're welcome.
Thank you.
And Barrister Justice, it was nice to have you on the show today.
Good afternoon. It is my pleasure once more.
All right. I'll start with you then. And reactions, accusations, counter-accusations has been going on in recent times in the country over the activities of IPOB and now the formal proscription of the group as a terrorist organization by the Federal High Court sitting in Abuja. What's your take on this?
Well, it is actually very unfortunate. Why I said it's very unfortunate, me as a lawyer, let me put it that way, I talk law. I don't want to base my argument or my submission on sentiment or tribal, whatever, but I talk law. It's so unfortunate. Why I said it's so unfortunate is that period to this time, Justice Nyako had already say that IPOB is not a terrorist group, and that Nnamdi Kanu is not a terrorist. So, and the government or whatever authority have not appealed that decision. So, going to approach another court, you see, that is one of the problems we have. When impunity becomes the order of the day in government, that is exactly the kind of thing you do. We must follow the rule of law in everything we are doing. Because as far as I'm concerned, that judgment still stands. And the second layer, there's even a fundamental error in that judgment of the Federal High Court. The fundamental error there is this: is IPOB a juristic person that you can sue? Yes or no? Because for the court to even assume jurisdiction, you must establish that the proper person is before the court. And these things were not done. So as far as I'm concerned, they are just playing to the gallery. As far as I'm concerned, by law.
All right. Barrister Samuel, what's your take?
Yeah, in addition to what my learned friend has
You
said,
subscribe to what he has just said?
Yes,
Okay.
And I want to add, bringing an ex parte application before the court, I think it denies the other party the opportunity of fair hearing. Such applications are so sensitive that it cannot be brought by way of an ex parte motion.
Okay.
The other party ought to have been put in notice. The other party, who is even a non-juristic person. So I think the application lacks fair hearing, and due process ought to have been followed.
All right, Barrister Adaramo, do you agree that due process was not followed in proscribing IPOB?
I think we have fairly talked about the issue, so to say. An organization that is not in existence cannot be sued in the court of law, cannot sue and cannot be sued. It is a tried thing in our practice. IPOB, as it may be, ordinarily, if the federal government will have taken a proper approach in this circumstance, I think what they could have done is to sue Nnamdi Kanu.
Nnamdi Kanu.
Yes, you understand. And the other people involved on behalf, as in representative capacity of IPOB. Undoubtedly, when you look at the way the federal government approached the issue. There's no doubt about that very fact. For one reason or the other, that they went about it in the very wrong way. And some people even have canvassed the argument, even though that one itself on its own is debatable. Some people have said, under the Constitution of Federal Republic of Nigeria, Section 39 and Section 40 of the Constitution, all things being equal, that is right of association, freedom of expression, and freedom of association, other fundamental human rights, that people could engage themselves, could express themselves as they wish, and at the same time, one way or the other, they could group and form association, and discuss issues. But the question, actually, that's why I said that one is debatable. What kind of freedom of expression? What kind of freedom of association? Is it inimical, to the healthy existence of the country, or to the will it amount to a violation of other people's rights? All those things are legal conjectures, you understand? But the way the federal government has approached the issue, vis-a-vis the issue of suing a non-juristic person, in law, I think as far as that act is concerned, that court order is concerned, it is illegal, invalid, null and void, to the extent of its inconsistent to the laws in the Federal Republic of Nigeria. So actually, I think I'm in sync with what with what my friends, learned friends have said.
All right. In approaching the court to prescribe the activities of IPOB, the Attorney General did cite the Terrorism Act, and I would ask Barrister Ohuebu, does the activity of IPOB in any way not seem as terrorizing the people of the region and also threatening the territorial integrity of Nigeria and also the unity of the country as well?
I said something earlier about the judgment of Justice Nyako. Justice Nyako's implicit in his judgment said that the government had not established enough facts or has not placed any facts to show that IPOB is a terrorism group or that Nnamdi Kanu is a terrorist. And that judgment still subsists. It has not been set aside. So any other thing we are doing now is going outside the ambit of the law. And that is why, you see, the problem here is, I don't know, let me put it this way. We are lawyers. We are supposed to be the custodians of the law. And even the Attorney General is also a lawyer. He was in company of the Solicitor General, and I think the Director of Civil Litigation. All these people are presumed senior lawyers. They are ought to know all these things. But I've discovered that in this country, when you want to play a script, you seem to back the law and do your own way, or play the script of the person. In fact, you are trying to please somebody. But let me tell you, as lawyers, I believe we all agree that we are taught in the law school that your first duty as a lawyer is to the state, to the country. Second to your client, then third to yourself. So if you now leave that duty that is supposed to be for the benefit of the country and now start playing a script, foul, you have lost it. And that was why, when we're talking about juristic policy, take time and read the judgment of Caribbean White in the case of Dangote versus Civil Service Commission, Plateau State. You see what the court clearly stated there. In Fawemi against NBA, also in Mojokodemi against Nkendelim, all these things were facts. You cannot sue a non-juristic person. Secondly, Nnamdi Kanu's matter is already before the court. And that was why the court said no. He's facing trial already for treasonable felony. then why? You see, the government should be very careful. It's easy to start something, but to begin to calm it down becomes difficult. Because when you start going ahead with your power, impunity, you prescribe this one, tomorrow I'm sure they might still want to prescribe Nigerian Union of Journalists as a terrorism group. Now, when you begin to do all these things, before you know it, there might be a synergy between all these groups you're regarding as a terrorist group. So we should watch it where we're going. As what I'm concerned, in as much as my little friend was saying something, I know where he was going. In as much as lawyers, by constitutionally, no right is absolute. And that is why if